This audio file is the property of LA Law Institute and is protected by copyright law. Unauthorized use, reproduction, distribution, or dissemination of this file without the express permission of LA Law Institute is strictly prohibited and may result in legal action. Any infringement of LA Law Institute's rights will be pursued to the fullest extent of the law. All rights reserved. First-degree murder. Only available under a statute, first-degree murder can be shown by 1. Specific intent along with premeditation and deliberation, 2. Poison, torture, lying in wait, etc. Or 3. Application of the felony murder rule. Common law does not use degrees of murder. Second-degree murder. Only available under a statute, all murders not listed under first degree are considered second-degree murders. Common law does not use degrees of murder. Accessory after the fact. Under common law, a person who aids principals after the commission of a felony. Modernly this is known as obstruction of justice. Accessory before the fact. Under common law, a person who aids and abets principals in preparation of committing a crime, but are not in attendance. Modernly, known as an accomplice. Accomplice. Under modern law, the common law labels of accessory before the fact and principal in the second degree have been combined under the accomplice label. The accomplice must have acted with the following: 1. The intent to assist; 2. The intent that the crime be committed; and 3. Actually aids or abets the principal. Accomplice liability. Guilt by association. Elements include 1. Intent to assist the principal; 2. Intent crime is committed; and 3. Encourages, aids or assists the principal. Unlike conspiracy, does not require an agreement. Actual cause. Actual cause is the but for cause of the harm. It may also satisfy the substantial factor test. Actus reus. The actus reus is the voluntary act which causes the harm. In certain circumstances, an omission to act may suffice. Aggravated. When a crime is committed using an inherently dangerous weapon or results in serious bodily harm, the offense may be upgraded to an aggravated crime. Additionally, if the victim is in a protected class, this may also serve to raise the crime to aggravated status. Arson. Arson is defined as the malicious burning of the dwelling of another. Under common law, burning your own home was not a crime. In order to satisfy the element of burning, there be a charring of the fibers. Blackening or scorching will not suffice. Malice may also be shown through recklessness. Assault. Under criminal law, an assault is an attempted but failed battery. It is also the intentional creation of apprehension in the victim of an imminent threat of bodily harm. Attempt. An attempt has 2 elements. 1. Is that there is an specific intent to commit the crime, and 2. An overt act in furtherance of the crime. Because an attempt charge may only be used with a failed crime, the attempt charge will control and the attempted crime will always be specific intent. Authority. A person may commit a crime if done under legal authority. For example, a police officer, school teacher or parent. Battery. An unlawful application of force resulting in a harmful or offensive touching of another. Battery is a misdemeanor. Aggravated battery occurs when the victim is a child, woman or police officer, or if an inherently dangerous weapon is used. Bribery. Offering anything of value in order to persuade a person. Bill of attainder. A statute which punishes or restricts without adjudication. Common law burglary. Breaking and entering of the dwelling of another in the night time with a specific intent to commit a felony inside. The breaking may be a constructive breaking when it was done via help of another, or by fraud or threat. The structure may also include surrounding buildings such as garage or barn, which is known as curtilage. But for actual cause. A test that asks but for the defendant's act, would the harm occurred. This is one way to determine liability. Causation. The requirement that the act was both the actual and proximate cause of harm. Compounding the crime. The taking of anything of value in exchange for an agreement not to prosecute a crime and or not to report a crime. Concurrence. The requirement that the guilty act and the guilty mind must occur at the same time. Consent. Before the defense of consent is used, 3 elements must be met. 1. The victim must have been informed of the consequences. 2. The victim must have given consent voluntarily, and 3. The victim must have legal capacity. Conspiracy. An agreement between two or more to commit an unlawful act or to commit a lawful act by unlawful means. Different from accomplice in that an agreement must be made. Modernly, a unilateral conspiracy is recognized in some jurisdictions when one conspires with an undercover officer. Additionally, an overt act or preparation is required. Constructive presence. Used to describe the involvement of an accessory before the fact, principal in the second degree or accessory after the fact in common law. The individual is not involved in the actus reus but is offered assistance either before, during or after to the principal in the crime. Crime prevention. If one reasonably believes a crime is about to occur, they may use reasonable force to prevent that crime. Curtilage. The outlying areas of a home such as a garage, barn, guest house which are included as a house in criminal law in such crimes as burglary or arson. Defense of others. When another is subject to the threat of imminent harm and was not the aggressor, a person may go to his aid and use as much as reasonably necessary to defend the non-aggressor. Some jurisdictions allow for a reasonable mistake. Defense of property. A homeowner may use whatever force is reasonably necessary when threatened with a life-endangering situation such as a trespass re-entry into the home or to stop a felony. Otherwise, lethal force may never be used to protect real or personal property. Defense of self-defense. When a person is threatened with imminent bodily harm, he may use reasonably necessary force to protect oneself. Deliberate. Carefully thought out. Done in a cool and dispassionate manner. Diminished capacity. Does not meet the requirements of an insanity defense, however it may negate specific intent due to mental defect or disease. Duress. Doing something under threat of imminent violence or great bodily harm. A defense to all crimes except homicide, however, it may be used for mitigation. Durham Rule. The Durham Rule, also known as the Product Rule or the New Hampshire Rule, is a complete defense under the category of insanity. It occurs when the mental defect is the but for cause of the illegal act. Embezzlement. Embezzlement is the wrongful conversion of personal property that was rightfully entrusted to the defendant. Specific intent crime. Embracery. An attempt to influence a juror. Entrapment. An entrapment occurs when an officer of the law initiates a criminal situation and the defendant was not otherwise predisposed to commit the crime. Excuse. A complete defense for a criminal act. Excuses include infancy, involuntary intoxication, and one of the 4 types of insanity defenses. Extortion, blackmail. Obtaining property from another by the threat of future harm. Factual impossibility. A factual impossibility occurs when the defendant attempts to commit a crime but fails to do so due to unforeseen circumstances. False imprisonment. The unlawful confinement of a person in a bounded area against his will without reasonable means of escape. The elements are 1. Unlawful, 2. Confinement, and 3. Without consent. Felony. A felony is a crime that results in at least 1 year in prison or the death penalty. Common law felonies were murder, rape, manslaughter, robbery, sodomy, larceny, arson, mayhem, and burglary. You can use Mr. and Mrs. Lamb as a memory device to remember the list of felonies. Felony murder rule. The felony murder rule is used when an accidental death occurs during the commission of a felony. Felony murder rule exceptions. Exceptions or defenses to the felony murder rule require one of the following. 1. The defendant must be guilty of the underlying felony. 2. The death must be independent of the killing. 3. The death must be foreseeable. 4. The time and distance of the death must not be too far from the actual crime. Or 5. The red line rule. This rule will come into play when a victim or a police officer is responsible for the death of a co-felon. Forgery. The false making or altering of a writing of apparent legal significance in order to commit fraud. General intent. The state of mind required which only requires proof that the defendant meant to do the harm he is being charged with. The fact that he did the act is sufficient proof to prove he meant to do it. Any defense of mistake must be a reasonable mistake. General intent crimes. General intent crimes include assault, battery, rape, false imprisonment, and kidnapping. Specific intent crimes. Solicitation, conspiracy, attempt, assault, larceny, robbery, burglary, false pretenses, and embezzlement. Malice crimes. Arson and homicide. Gross negligence. Negligence that is far below the standard of duty of a reasonable person. May be considered recklessness or criminal negligence. Heat of passion. A type of provocation that mitigates a first or second-degree murder charge to voluntary manslaughter. The elements are 1. There must be a provocation. 2. Defendant was actually provoked. 3. There was no cool-off time. And 4. The defendant did not cool off. Homicide. The killing of one human being by another without excuse, justification or mitigation. House burning. The malicious burning of one's own dwelling which is located either in a city or near other houses, creating a danger. This is before homeowners insurance and was not illegal. Imperfect self-defense. An unreasonable mistaken belief that a deadly force was required due to the immediate situation. Only applies to murder or attempted murder. Inchoate. Imperfect or incomplete. Inchoate crimes are solicitation, conspiracy, and attempt. All inchoate crimes are specific intent. Infancy. A common law defense which follows the rule of sevens. 0 to 7 years of age, no liability due to lack of mens rea. Ages 7 to 14 come with a rebuttable presumption of innocence unless engaged in adult activities. Over 14 are held to the same standards of an adult. The age is based on chronological age. Insanity. Insanity is a defense used under the excuses category and is a complete defense if proven. There are 4 versions of the defense depending on the jurisdiction where the crime was committed. The 4 types are 1. Newton Rule 2. Irresistible impulse 3. Substantial capacity /Ali/MPC and 4. Durham/product rule. Intent, Model Penal Code. The Model Penal Code does not include general or specific intent. The MPC uses purposefully, knowingly, recklessly or negligently. See individual entries for each MPC form of intent. Involuntary intoxication. Ingesting a substance that causes intoxication without prior knowledge of effect. May be errant fumes, reaction to medication or other unforeseen causes. If proven, it will equate to an insanity defense. Involuntary manslaughter. Involuntary manslaughter is a homicide committed without malice. Criminal negligence is the mens rea. Death during a non-felony, typically a malum in se crime, is considered a misdemeanor manslaughter. Irresistible impulse. A complete defense that falls under the insanity category. It occurs when, due to a mental defect, one cannot control one's actions. Justification. A complete defense to a criminal act. Defenses include self-defense, defense of others or defense of property. Also consent, authority, and necessity. Kidnapping. The asportation of a person from one place to another or the hiding of a person. The movement and concealment are the required elements to prove a case. Knowledge or knowing. The mens rea for receiving stolen property. Under the Model Penal Code, done with substantial certainty or conscious objective of the resulting harm. Larceny. The trespassory taking and carrying away of the personal property of another with the specific intent to permanently deprive. Note, lost or abandoned property does not belong to another. Larceny by false pretenses. A form of larceny where title is obtained through fraud, deceit or misrepresentation. May also include passing bad checks or misuse of another's credit card. Larceny by trick. A form of larceny where the custody, possession, of a chattel is gained through fraud, deceit or misrepresentation. Legal impossibility. A legal impossibility defense is used when the acts of the person are not illegal and do not constitute a criminal offense. Macnaghten Rule. Due to a mental disease or defect of the mind, one does not know what they are doing or that what they are doing is wrong. This is a complete defense under the excuse category. Malice. A state of mind in murder and arson cases. It may be proved by showing that the defendant acted recklessly or disregarded the potential risk of harm. May be expressed or implied. Please note, malice aforethought is a different mens rea. Malice aforethought. This is the mens rea for murder. It may be shown by 1. An intent to kill, 2. An intent to commit great bodily harm, 3. An intent to commit a felony which is known as the felony murder rule, or 4. A wanton, willful disregard for human life which also called a depraved heart. Malicious mischief. The malicious destruction of someone else's property. Malum in se. A crime that is inherently wrong according to the beliefs of most societies, such as murder, larceny or battery. Malum prohibitum. Acts that are criminal due to a statute that prohibits the behavior in order to benefit society. Mayhem. Mayhem is the malicious disfigurement of another. Mens rea. The state of mind that must accompany a voluntary act in order to bring a criminal charge. This intent may be specific, general, malice or strict liability. It is known as the guilty mind. Merger. When a lesser included crime has all the elements of a greater crime, the lesser crime will merge. For example, larceny will merge into a robbery because all of the elements or larceny are found within a robbery. Merger also applies to solicitation and attempt, which merge with the completed crime. A defendant may be charged with both crimes but may only be convicted of one. Misdemeanor. Misdemeanors are crimes that are punishable by prison terms of less than 1 year. Misdemeanor manslaughter. When a killing occurs during the commission of a misdemeanor, it is called a misdemeanor manslaughter. This is most commonly found with larceny, assault or battery. Misprision. The failure to disclose the known felony of another. Modernly, known as obstruction of justice. Mistake of fact. A mistake of fact can be used to negate mens rea. A reasonable mistake of fact can be used to negate a general intent crime. An unreasonable mistake of fact can be used to negate specific intent crimes. Mistake of law. The defendant acted with misinformation or mistake regarding a law. However, a mistake of law is generally no excuse for a crime. Mitigation. A partial defense to reduce the severity of a crime to obtain a lesser penalty. These include heat of passion, imperfect self-defense, mistaken justification, coercion or duress. Model Penal Code. A standard set by a group of law scholars on what the law should be. Developed in 1962 by the American Legal Institute, it proposed a uniform set of laws that could be used to simplify, consolidate and unify U.S. criminal law. Murder. Under the common law, a murder is a homicide committed with malice aforethought without justification, excuse or mitigation. Modernly, murder is divided into categories of first degree and second degree. Necessity. Necessity may be used as a defense when it is used to protect against a harm greater than the offense. It is unavailable if the defendant caused the situation. Negligently. Defendant should have known or been aware of an unjustifiable risk that his act will result in a crime. Omission to act. In most cases, crimes are affirmative acts. However, failure to act will suffice when the defendant has a duty. There are 3 instances in which this will occur. 1. When the defendant has knowledge of the facts. 2. It is possible for the defendant to perform the act. And 3. There is a legal duty to act under the following circumstances. A statute, a contractual relationship, the defendant assumed a duty of care or the peril was created by the defendant. Perjury. Perjury is lying under oath in a judicial proceeding. Pinkerton's rule. All members of a conspiracy will be held liable for the crimes of the co-conspirators, if they were foreseeable and in furtherance of the target crime. Premeditated. As used in criminal law, premeditated means that the crime was thought about or considered. It is used as one of the elements in a first-degree murder charge. Principal in the first degree. Person who actually commits the felony. Principal in the second degree. One who is present at the crime and aids, commands or encourages the principal. Modernly called an accomplice. Proximate cause is used to determine the scope of liability. If the harm happened without an intervening, superseding or unforeseeable act to cut off liability, it is the proximate cause of that harm. In simple terms, if the resulting harm is foreseeable, it is the proximate cause. Intervening events may be due to third parties, acts of nature or potentially even the act of the victim. Purposefully. Defendant has a conscious objective to do the act or cause a certain result. Rape. Sexual intercourse with a woman without her consent. Rape is a general intent crime. Receiving stolen property. Receiving property that is stolen with the knowledge that it is stolen and the intent to permanently deprive the owner. Recklessly. Defendant acts with conscious disregard of a substantial risk that his act will result in a crime. Also referred to as wanton. Red line rule. Under common law, the co-felon is liable for all foreseeable deaths resulting from crime. Modernly, when a co-felon is killed by a non-co-felon, the felon is not liable for that additional resulting death. Robbery. Robbery is a larceny which is done with a threat of force or violence. All larceny elements must be met in addition to the threat of force or violence. Sodomy. A common law crime which is used in charges of bestiality or sexual practices which a jurisdiction may find objectionable. Solicitation. The urging or asking of another to commit a crime whether or not the other agrees or if the crime actually occurs. Specific intent. Committing a criminal act in order to accomplish a second objective. For example, a burglary is done with the intent to commit an additional crime once inside the house. Specific intent, defenses. Any defense that can disprove the mens rea may be used. Additional defenses include unreasonable mistake of fact or voluntary intoxication. Statutory arson. Modernly, the malicious burning of any structure including cars. Statutory burglary. A trespassory entry into any structure, including autos, at any time with intent to commit any crime including petty theft inside. A trespassory entry is any entry without consent or exceeds given consent whether express or implied. Statutory rape. Sexual intercourse with a female under the age of consent. Strict liability. An act that does not need to be accompanied by a guilty mind. Acts that have been labeled strict liability hold the defendant liable regardless of intent. They may be administrative, regulatory or public safety. Such crimes are statutory rape, selling alcohol to minors and certain traffic offenses as well as others defined by the jurisdiction. Subornation of perjury. The asking or requesting of another to commit perjury. Substantial capacity or the A.L.I. test of insanity. This test holds that if the defendant lacks substantial capacity to understand his actions or to conform his actions to legal requirements, he may use an insanity defense. This is one of the 4 tests of insanity that combines the Newton rule and irresistible impulse tests. ALI is the American Legal Institute. Substantial factor. When more than one person is responsible for the harm, each may be liable if the harm was a substantial factor in causing the harm. Theft. The modern name used to combine all larcenies. Transferred intent. When an act is done toward one victim and is accidentally applied to a second victim, then the defendant is liable for 2 criminal acts. One for the intended victim and one for the unintended victim. Typically found in homicide, arson and battery. Applies only to general intent crimes. Uttering. The use of a forged document, knowing it is forged with the intent to defraud. Voluntary intoxication. A defense that can negate specific intent requirements of a criminal act. Voluntary manslaughter. Murder that has its penalty reduced due to mitigating circumstances such as heat of passion or imperfect self-defense. Wharton's rule. A conspiracy cannot be committed in a crime requiring 2 individuals unless a third defendant has agreed to be involved. These crimes requiring more than 2 participants include bigamy, incest, gambling, bribery, adultery, and dueling. A good memory device is big bad. Criminal negligence. Negligence that is beyond unreasonable but is not malicious.